We are on the record for hearings in the matters listed in the North Dakota Industrial Commission hearing docket for December 3rd. I'm David Garner, hearing examiner for these hearings. We're at the hearing room for the Department of Mineral Resources, Oil and Gas Division, and it is 9:01 a.m. The docket includes two cases that will be consolidated for the purposes of hearing. Case number 32367, petition of EOG Resources, Inc. for an order providing for the unitized management, operation, and further development of the Alger Bakken unit area, consisting of lands within the portions of the Alger Field and Cottonwood Field in Montreal County, North Dakota, for approval of the unit agreement and unit operating agreement constituting the plan of unitization for the Alger Bakken unit area, for approval of the plan of operation, vacating the applicable spacing orders, and for such further and additional relief. Case number 32368, in the matter of the application of EOG Resources, Inc., for an order of the Commission determining that the plan of unitization for the Alger Bakken unit area, consisting of lands within portions of the Alger Field and Cottonwood Field, Montreal County, North Dakota, has been signed, ratified, or approved by owners of the interest owning that percentage of the working interest and royalty interest within said unit, as is required by applicable statutes and rules of the Commission. All interested parties, please come forward.
Thank you, Mr. Examiner. Lawrence Bender, P.O. Box 1855, Bismarck, North Dakota. You may need to repeat. Should I repeat? Thank you, Mr. Examiner. Lawrence Bender, P.O. Box 1855, Bismarck, North Dakota. Appearing in these matters, case number 32367 and 32368 on behalf of EOG Resources, Inc.
Ms. Morgan, please raise your hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, I do.
Good morning, Anna.
Good morning.
Anna, could you tell us by whom you are employed
EOG Resources Incorporated,
and in what capacity?
Land Advisor.
And in that capacity, have you testified before the Commission previously?
Yes, I have.
Had your qualifications accepted as that of an expert?
Yes.
Offer the further testimony of this witness that of an expert.
Motion granted.
Anna, what I'd like you to do first of all is turn to the packet of exhibits for case 32367. I realize these are consolidated, but I want to direct your attention first to this set of exhibits. And let's turn to what's been previously marked as Exhibit L1, first exhibit in the packet. And what I'd like you to do, Anna, is identify Exhibit L1 and then briefly describe what's contained on that exhibit.
Exhibit L1 is an area location map. It shows the area of interest within Montreal County, North Dakota. Outlined in purple is the Cottonwood Field, and outlined in green is the Alger Field that are both involved in this case, and shows how those fields relate to the other producing fields in the surrounding area. It also identifies the city of Stanley nearby, just for geographic reference.
And your proposed unit, that's outlined in blue, is it not? Or
Correct.
Did you say purple? Or
No, the field is outlined in purple,
Okay.
Cottonwood Field. Our proposed Alger Bakken Ross unit is outlined in blue.
and that blue overlaps a portion of Alger Field and what was the other field? Cottonwood Field.
Yep.
Is that correct?
Yes.
Okay. Let's go on then to the next exhibit, L2. Can you tell us what L2 is?
L2 is a larger scale, more detailed map focusing specifically on the immediate area around the proposed Alger Bakken Ross unit. It's zoomed in to show the unit area with much greater clarity. The unit is, the proposed unit is 14,029.45 acres, more or less. And it's outlined in blue, and this shows all of EOG's development within the unit boundary.
And in terms of history of development, and I know you're very familiar with this area, can you briefly describe? My understanding is that initially this area was developed on one well to 640 acres. Wells were drilled diagonally, and then subsequent thereto, there was a desire or a need to further develop the field, and that diagonal pattern continued. Can you just talk a little bit about that and some of the problems diagonal drilling on these spacing units created, and why we're here today for the unit?
Right. So yes, you're correct. This area was originally spaced on 640 acres. We did the diagonal wells. That was how they had their plan of development at that time. There are a few outliners up in sections 23 and 26 in Cottonwood. They did a 1280, and they did a couple of other, longer laterals in there. But what this does is, for us to avoid as many wellbore crossings as we can, we'd like to stay on that diagonal pattern. And what that creates then, if we do this on a drilling unit by drilling unit, is all kinds of overlapping spacing units. So putting this into one consolidated unit avoids all of those individual overlapping spacing units.
And there's been a fair amount of overlapping spacing units already created and drilled in this proposed unit outline. Is that correct?
Yes.
And if this unit is formed, that will eliminate the need for overlapping spacing units because this entire area will be created as a primary unit. Is that correct?
Correct.
Okay. Let's go to the next exhibit, Anna, Exhibit L3. That's entitled Unit Agreement. To your understanding, is that a standard or typical unit agreement form that the federal government requires when the federal government has mineral interests in a proposed unit?
Yes, it is.
Okay, and then of course it has the modifications to that form that are necessary to include a track participation formula and other things that don't come with the form that need to be unique to the unit. Is that correct?
That's correct.
Okay. Now you talked a little bit about the fact that there have been some overlapping spacing units in this area, and there was a recent overlapping spacing unit. Can you discuss just briefly what the most recent overlapping spacing unit was and what that has been drilled?
Yes, we have.
Maybe we need to go back to Exhibit L2.
Yes, I don't have it called out on here.
Okay.
But down in the southwest, if you'll refer to Exhibit L2, the southwest of Section 16, EOG drilled 3 longer laterals from the southwest of 16 up into the west half of Section 6
Okay.
in 15692. That was a spacing unit that we created earlier this year, and we drilled those wells last summer. We completed them in October.
Okay. So has EOG taken into consideration the fact that those wells were recently drilled, and then of course there was some time between when they were drilled and when you actually put those wells on production? Has EOG taken into consideration what the allocation should be with respect to the costs of drilling those wells and the allocation of production, given the fact that if our request for an effective date is granted, the period of time between when the wells were drilled, completed, and producing to the time of the effective date is going to be a very short time period?
Yes. We have addressed that in Section 10.8 of the Unit Operating Agreement.
Okay, let's go to 10.8 of the Unit Operating Agreement,
Okay.
and then you can summarize what that section provides for and why you believe it's necessary to be included in the unit agreement.
Yes. Provision 10.8 is within Article 10, Adjustment of Investments.
Okay, now you're in the Unit Operating Agreement,
Yes,
correct?
correct.
Okay. And maybe I should ask you this question before you get into the detail. The Unit Operating Agreement is a typical unit operating agreement that the Commission has seen many times and has been utilized for other situations where a federal form of unit agreement has been utilized. Is that correct?
Correct,
Okay.
yes.
And I apologize for having
Sure.
to go back, but now let's go to
Fine.
Section 10.8, I think you said, of the Unit Operating Agreement.
Yes, it's on page 13 of the Unit Operating Agreement.
Okay, just give us a moment to get there. Page 14, you said?
13?
13? Okay. All right, go ahead.
Yes. So how we've addressed this, these 3 wells, it's the Ross 39-1606H, the Ross 102-1606H, and 103-1606H. When this agreement in this unit is formed, we will go back to inception of those 3 wells. They were drilled last summer, and we'll go back to last summer and recalculate all of the expenses that have been paid for those 3 wells to put them into, to reflect the unit ownership rather than the DSU ownership.
So when the wells were proposed, drilled and completed, all the allocation for expenses was done on a spacing unit basis, correct?
That's correct.
And that spacing unit was approved by the Industrial Commission. Is that correct?
Yes,
And now what you're requesting with your section 10.8 in the unit operating agreement is that after the effective date of the unit, EOG would go in and readjust the allocation of those expenses.
that's correct.
And why do you think that makes sense?
Because those wells there was no production on in those wells before this unit was produced or proposed.
So certainly, if you're going to allocate production on a unit basis, you need to reallocate the expenses for those wells.
Correct.
Yeah. Otherwise, you really wouldn't protect correlative rights, would
Correct.
you? Okay. I think that's all the questions I have for this witness.
Any questions from the staff?
So Anna, the last topic you discussed, I want to make sure I understand. So the expenses have been paid for on a space unit basis for those 3 wells,
Yes.
and the production, have revenues been distributed on those wells?
No, they were turned to production on November 4th, and our plan, or our hope is that we can get the unit approved before we're required to pay out any revenues on those wells.
So those revenues are just being held in suspense at this point?
Yes.
Okay, thank you.
Anna, can you go back to the map and just make sure I probably was catching up when you were talking about that? I've got this part down, but I'd like you to explain those lands that are impacted by this particular, and those wells that are impacted by this particular 10.3. I'm assuming it's the second page.
Exhibit L2. So the spacing unit for those 3 wells was the west half of section 16, all of section 17, sections 8, 7, and 6.
Mr. Director, if it would be of assistance, we'd be happy to provide a supplemental exhibit laying out on a map those lands in the spacing unit.
I think I got it.
Pardon me?
I think it's okay.
Okay, great.
Yeah, I think I got it. It's so just to make sure it's section 6, 7, 8. That's 1. Is that right? Or is that 6, 7, 8?
6, 7, 8, 17, and the west half of 16
Is all
was
one
all one
particular?
spacing
Okay.
unit.
Yep, I got it. It's okay. Lawrence, I'm good. And so all of those wells, none of the production on any of those wells has been distributed?
Just the 3 wells, the 3 longer laterals that are, the surface location is in the southwest of section 16, and the 3 laterals go all the way up into the west of section 6.
Actually, Lawrence, I think it'd be good, and then indicate that those wells, yeah.
Okay.
I understand.
Sure.
I see which wells those are now.
We can
And
provide
just
that.
maybe for the record, what we'll do is probably submit it as a supplemental land exhibit, and probably take off all the wells except for the 3 wells in the spacing unit that we're asking the commission, or that the unit operating agreement addresses how expenses and proceeds of production will be handled.
Thank you.
You bet.
Anna, bear with me here. Let's start with, I guess, your L2. Can you give us an idea why that west half of 31 is included? And there's a disconnect between what looks like the western edge of the unit, and then it kicks up to the east there again.
Right. The west half of section 31 is operated by EOG Resources. Going to the east, Hess operates those units over there, and they've drilled some wells in the east half of 31 and 32 and down into those other sections over there. So that's all been fully developed. It's just the west half that still has some room over there.
Okay. And I should have started, the wells depicted on this map are just EOG wells. It's not
Correct.
showing any of the others.
Yes.
Okay. I'm assuming 24, 25, and 36 are also another operator.
Those are operated by Hess, and we have discussed this unit with them. They're not opposed to the unit, but they did not want to include their DSU within the unit boundary.
Okay. Exhibit A, as part of the unit agreement.
Yes.
So this exhibit, the legend down in the lower left-hand side, has patented lands. Can you give me an idea what patented lands is?
Those are fee tracks.
Just fee tracts?
Yes.
Okay. And then federal lands on this exhibit are outlined in the dark black outline.
Correct.
With respect to the federal lands, are there any unleased federal acres in here?
No.
Okay. The entity that has leased the acreage, then, is that indicated at the top of each of those black outlines? Is that the leaseholder of the federal tract?
It's the record title holder.
Record title holder. Okay. And is that the same then, I guess, for the state tracts, the blue hash?
Blue hash, yes, that's correct.
And the number at the bottom of those identified tracts, that must be just the number that identifies the lease or either the federal lease or the state lease. It's a unique ID to that tract.
Yes.
Okay.
The numbers in the circles are the tract numbers.
Right. I was talking about the number on the
Yes. That
individual.
indicates the state or the federal
Yeah.
lease number.
I guess one note, the tract in the southwest of tract 18, which happens to be section 18, that owner in there, whatever that was supposed to be, is illegible on the exhibits. I can't make it out.
Okay, I can send
Really,
you-
really fine, tiny print.
Yeah.
I guess if you could confirm who that is, or maybe supplement with something that's legible on there.
Sure.
Flipping into the unit agreement.
Do you say unit agreement?
Yep.
Okay.
I guess I might have to reference Exhibit A still here, but on page 2 of the unit agreement, Article 2 of the unit area is listed as 14,029.45 acres. That looks to be high if they're all straight up 640s. I'm assuming, looking at Exhibit A, am I correct that sections 3, 4, 5, and 6 are larger than average sections?
Yes, those.
I think that's reflected in Exhibit B too.
Exhibit C
Okay.
to the unit agreement shows the acreage by tract, and there are some sections that are over regular sections.
Okay. As Lawrence indicated when he was talking, or when he was questioning you, this unit agreement takes the federal form.
Yes.
For the most part, in a number of places through the unit agreement, it references federal approvals being needed from the authorized officer from the BLM, right? I recognize that there was some work put into this one. The NDIC has been included in a few spots. I'm not sure quite hit all of them, but would you agree that anything the unit agreement addresses that would require state approval as well would also require state approval and not just federal approval if it's statutorily required by.
I think that's a legal question. Let me respond. There are things that cannot be changed in the unit agreement without the approval of the Industrial Commission. There are things in the unit agreement that cannot be approved without the authority of the authorized, without approval by the authorized officer. But I would not say that they're totally consistent. There are some things that the Industrial Commission may have to address and approve that the authorized officer may not have to deal with, and vice versa. So hopefully that answers your question.
It does. I just want to make sure it's clear that regardless of whether or not this unit agreement indicated that some facet in here required NDIC approval, if statutorily that change or amendment would require, you recognize that even if this unit agreement doesn't specifically indicate it, that approval would need to come from the Industrial Commission as well.
We recognize that this agreement would need to be approved under the statutes and rules and regulations of the commission. If the Industrial Commission were to go to the legislature and there were some modifications to the statutes, we're not willing to concede that those would be necessarily retroactive and that we'd have to go back and seek the Industrial Commission's approval for this unit again. Possibly, but unlikely.
Not necessarily for the unit. I'm talking about, say, transfer of operatorship. I think within the unit agreement, it references requirements that transfer of operatorship would require the authorized agent or authorized officer. The Industrial Commission would also have to approve transfer of operatorship of all the wells.
We recognize that and have no objection to that.
And that's what I'm talking about.
Okay.
Anything that would require state approval, even if it isn't referenced in the unit agreement, would still require that state approval.
Yeah, I mean, this unit agreement is governs generally the operation of the unit, but there are specific things in the statutes and rules and regulations of the commission that overlay all of this that EOG would have to comply with.
Okay. So this is kind of an odd line of questioning, and I just want to understand a little bit better. When you have federal acres that are leased, it isn't just the leaseholder that has to approve or commit to the unit if they're going to ratify the unit. You also still need the federal government's approval of the overall unit because it includes federal acreage.
Yes, that's correct.
Unit agreement, page 3, article 4, the unitized substances. This is kind of a minor thing, but the last paragraph there, the form that was used to represent the API number for the type log or type well in here, that's an odd ordering of the numerals in the API number. Was there any particular reason it was done this way?
No, I believe that was just a Scrivener's error.
Okay. Yeah. The number is correct in this case. It's just not the typical
Dash in
form. The log, the type log referenced in this unit agreement, the Erie 4419. That log and the Commission's well file records indicate that there's a KB elevation of 2,460 feet for that well. It would appear, looking at the TBD values that you're reporting associated with the Bakken Formation top and Birdbear Formation top, have an additional 2 feet baked into them from somewhere. as if a KB of 2462 was used. So I think the 2482 subsea TVD for the Bakken should be 7482 should be 7484, and 7848 should be 7850.
Mr. Suggs, is that maybe a question that could be raised with our next witness, geologic engineer, in the event that he has some sort of response, rather than taking him out of order now? We just address that at that point in time.
Yeah, if you want to address it when you're doing your testimony, that's fine.
Yeah.
But I'm just going to mention, I think it's just a typo, and I think they should just be changed.
Okay.
If that can be confirmed, that'd be great.
Okay.
Page 4 of the unit agreement, Article 5, tracks qualified for participation. The language at the bottom of the first paragraph here reads, for the purpose of this section, the record interest shall replace the royalty interest as to federal lands. Can you give me an idea what? I just don't understand what that language is. What that's doing, or what?
Let me try to explain this, Mr. Suggs. Section 5 is all information or requirements that the federal government insists that we include in the form of unit agreement. In the past, as you know, I've done a number of units before the commission where we have attempted to convince the federal government to make changes, and they're not very receptive to that. This is their form. This is what they want to use. They'll allow changes, like rather than using the governing entity as the Montana Board of Oil and Gas, they will allow the North Dakota Industrial Commission to be substituted. But I think you can take a look at Section 5 and basically say that we ignore everything in Section 5 except for the last paragraph, which provides, quote, notwithstanding anything in this section to the contrary, all tracts within the unit area shall be deemed to be qualified for participation and be deemed committed if this agreement and the unit operating agreement are duly approved as the plan of unitization and operating plan by order of the North Dakota Industrial Commission, State of North Dakota, and the AO. That is the language that we are proceeding. We're not going to attempt to get any of these tracts committed by any other manner. We're going to the commission. We're going to submit to the commission, probably not today, but at a later date, that we've received 55% of consent or ratification from the working interest owners and 55% of ratification from the royalty owners, and we will ultimately get approval from the federal government. So it's only the last paragraph of Section 5 that we're going to be dealing with. The rest of it is, as far as EOG is concerned, meaningless.
Okay. I was going to ask something along those lines. Effectively, if we approve and the unit is ratified, the ratification and our approval constitutes the tracts participating in the unit.
That's correct.
Okay. Page 5, Article 7. Resignation or approval of the unit operator. Again, I think this has already been answered, but along the lines of the transfer of operator would require NDSC approval. I think we've already answered that. So,
Yes.
Page 7, plan of operation. So Article 11, plan of operation. The first sentence in there reads, it's agreed and recognized and agreed by the parties that the unit area is developed and productive, and only such drilling as is incidental to enhanced recovery program is contemplated. Is there a conflict with the language there in that this is proposed as a primary development unit, right? So the intent is to drill additional wells to develop the unit, or is it sufficient that the drilling of those additional wells is the enhanced recovery program, and that's where the additional oil comes from? Or that's probably an unfair way to phrase that, and maybe it's for the engineer, but
Mr. Suggs, this is a form provided by the federal government. The federal government does not have a special form for a primary unit. As you know, this is a primary unit. There's not going to be any injection of any fluids into the reservoir. But as I've indicated, we can't convince the Bureau of Land Management to change their form. If you think you might have some success, we welcome your attempt to do so. But we have not had any success over the last 20 or some years. This is the form. And if you want to include something in the order that addresses the issue that you just raised, we don't have any objection to that, because there is no intent to inject any fluids in this. And clearly, the unit is being put together to allow for a more effective and efficient manner of increased density without having these many overlapping spacing units.
right. And I think the commission agrees with the approach. I just want to make sure that we don't have, functionally, when we approve a unit, we take and incorporate the unit agreement into that approval process. And if there's conflicting language, if it needs to be addressed in some way, we'd like to do so in the order, if at all possible.
I don't think that the federal government pays any attention to the order that the commission enters in this. I think they rely on this, but I don't think there's going to be any inconsistency. And we'd be happy to provide some language that could be inserted into the order that would say, notwithstanding maybe this provision or any other provisions in the unit agreement or unit operating agreement, this is a primary unit, and it's being developed. It's being put together for the reason of increased density along the lines that Mr. Schmidt is going to testify later on. If that's something that you believe might be helpful for the commission, happy to provide it. I don't think it'll cause us any problems with the federal government. I don't think the federal government even reads the commission order. I think they just rely on their form of unit agreement.
Okay. I think it might be beneficial if you wanted to supplement some suggested language that would address some of those kinds of inconsistencies between this and...
Yeah, happy to do so and fully understand, your concern. But we've been doing this now for many years, and no problems. That's not to say a problem won't come up in the future, but I think if that's a concern of the commission, I think it can be best handled with some proposed language in the order.
Okay. I would appreciate if you'd submit something kind of suggesting how that could be crafted.
Be happy to write the order if it'll help the commission.
If Mark assigns it to me, I might ask you to. Still on unit agreement, page 7, the right to inject substances, the last paragraph there, just confirming. So this paragraph references the unit needing approvals of the authorized officer. But when it comes to injection of fluids in the state of North Dakota, as state has primacy, you would have to seek North Dakota approval for any injection activities should it take place in the future.
Understood.
And just once again, I think we'd have to do more than that in this case, because I don't think the unitization order that we're requesting or that we're contemplating receiving from the commission is going to allow for any injection. It's a primary unit only for additional drilling.
Okay. Would you want language along those lines in the order, or I mean, typically, I think the orders we've done have allowed potential injection even in a primary unit, with the understanding that should you choose to go that way, we might have to come through a hearing process to approve stuff further. But
That would be surprising to me if the previous orders for primary units allow for injection, because I think, and John can speak to this better than I when we get to his testimony, but I don't think we would be proposing the formula that we proposed if it was a unit where we were going to be injecting, because we'd be moving oil. We've come up with a formula for allocation of production based on just extraction, no pressurizing the reservoir, no moving of the oil. So I will let John address that, but I think that would be a problem if the commission were to include language that we could convert this to a secondary recovery operation merely by making application to the commission for applications for fluid injection, for underground fluid, under the underground injection control program.
can I get sworn?
No, let's just wait.
Think. Unit agreement, page 12, article 20.
Did you say Article 12?
Page 12, article
Page
20, effective date. Again, recognizing this is the federal form, requires the approval of the secretary. In this case, will have an effective date established by the commission as well via our order. Does there end up being any kind of problem if those two dates don't coincide?
Absolutely. And in the past, what we have done is we have attempted to get the approval of the authorized officer or the representative of the secretary to coincide with when the commission also approves the unit. It would be not advisable for the commission to enter an effective date of, I'll just use an example, January 1, 2026, and then have the federal government say the effective date of the unit is February 1, 2026. The two dates have to coincide. We've not had problems in the past. I shouldn't say we haven't had problems. We've always been able to get the dates to coincide. There's been some times when it's been difficult to get that done, but the dates have to coincide.
Is there anything? Which one's chicken and egg situation? Which one's the egg? Which one has to come? Does the commission have to have its order out there for the federal government to approve their end, or is there some preliminary approval that the feds will give, indicating that yep, they'll sign it as soon as it's authorized by us?
My experience with the federal approval is it's a two-step process. The first step is they designate the area as a logical unit area. After that, go forward with the hearing, and then after the commission issues an order approving the unit, then we coincide the dates of the effective dates with respect to the application having to do with the ratification. Now, they haven't designated this as a logical area yet, but as you know, the government's been shut down for some time, and Ms. Morgan has made numerous attempts to have a meeting with the Bureau of Land Management to get them to designate this as a logical area. I believe that meeting's been set for
December 16th.
Yeah, so that's when that's likely to take place. So my recommendation would be is that perhaps the commission could go forward, if it deems appropriate, approving the unit. The federal government would go forward with designating the area as a logical unit area, and then the director then be given authority under the ratification portion of the application 32368 to issue an order with an effective date that's consistent with what the federal government also would provide as an effective date. That's how we've done it in the past. That's worked pretty well.
I know in the past we've also received a supplemental in some cases that the federal government has deemed it a logical area. Is that something you expect to receive in the short-ish term, or would it be appropriate to leave the record open to receive that? Or
Yeah, I think that could be submitted with respect to case 32368, and we're going to request that the record remain open for that. We're going to request that the record remain open in that case for other reasons. One, when we get to that case, Ms. Morgan is going to testify that we're not at the 55% level for the royalty owners, and it's not because we don't have royalty owners that support. It's just the interests are very, very small. And Ms. Morgan will testify to the fact that she's getting telephone calls and say, "Oh, my interest is so small. We didn't really think you needed our support." But because the interests are so small, we do need their support. Plus, we're anticipating getting the support of the state of North Dakota, which would easily take us over the 55%. So I'm sorry I'm giving you a long answer to a short question, but I think it would be entirely appropriate for that the record remain open for additional ratifications, and those additional ratifications could include the area being designated as a logical unit area by the federal government, and then their actual support where they would be deemed to have ratified the unit agreement.
okay, and then I think my last. I won't say that yet. Unit agreement, still page 12, article 21, the term. 'Scratch that. I think we've already covered what I was going to get at there with the approval from the state on that as well. In the unit operating agreement, page 15. Existing non-consent interests.
I'm sorry, what section?
It's Article 11.8.
11.8, okay.
Existing non-consent interests. Are there any, at this point, are there any non-consenting interest parties?
Yes, there are.
Okay. The language in this indicates that. Am I correct in my understanding, I guess, that the language in this article, if there's a non-consenting entity subject to, say, a tax, or not tax, but a risk penalty, this article would indicate that that risk penalty would be continuing to be paid out only on the proceeds allocated to the tract, or would it be the proceeds of the whole unit that would contribute to that risk penalty?
Consistent with what the Industrial Commission's position was in a recent case. I can't remember the full name. It was a Liberty. It wasn't my client, Liberty Resources, but it was a Liberty entity. I represented XTO and Continental Resources in the case. The Commission's position on that was that if there was a risk penalty that needed to be applied to one tract and then the tract was unitized, the commission made the determination that recoupment of the risk penalty could be recovered from all of the tracts of that owner in the unit. That case went to the district court and ultimately to the North Dakota Supreme Court, and the North Dakota Supreme Court affirmed the commission's determination that the risk penalty comes out of all of the interests from all of the tracts that owner went non-consent on.
And this language conforms with that. Okay, that's. I wasn't quite sure on the wording. I wanted to make sure that was in line. Page 17 of the unit operating agreement. Article 14.1. On that same line of unleased mineral interests being treated as, this addresses the unleased mineral interest being treated as a working interest and a royalty interest. I guess I'm not entirely sure how that typically works with respect to ratifications and approvals. I understand that if a party that has both a mineral interest and a working interest, a working interest and a royalty interest, ratify its ratification for both. But when it's a 7/8 to the working interest and a 1/8 to the royalty interest, do you factor that into the approval somehow or the ratification? I'm not.
Yes, that was allocated in this way, that it was allocated 7/8 to the working interest and 1/8 to the royalty interest.
So in Exhibit B, where some of the owners are identified as where's that? I think it's UMI. I'm assuming that's unleased mineral interest.
Yes.
And then if they ratified, you would account that as 7/8 towards the working interest and 1/8 towards the royalty interest.
Yes.
Okay. Exhibit D in the unit operating agreement.
Get out the magnifying glass. Huh?
Yeah.
Kind of like Exhibit B, it goes on for pages. The form of this, I just want to make sure I understand. This is showing each the interest of each owner in the unit. Are the ones that are working interests the only ones that have values under the working interest phase 1 and phase 2 columns?
Correct.
Okay, so all of the other ones on here, they're not working interest specific. They're the
They're
royalty.
either royalty or
Okay.
override.
Just want to make sure I had that clear. And then maybe one more quick question on Exhibit B. Actually, two questions on Exhibit B for you. In Exhibit B, under the interest type, there's working interest, royalty interest, overriding royalty interest, that unleased mineral interest that we indicated, and there's one more. It's PP.
Production payment,
Production payment.
similar to an override.
You say similar to an override. Does it participate in the same way in that the override isn't a voting entity, it's a carved out interest, or does it?
No, the production payments are not included in the ratifications.
Okay, so like an override, then it doesn't get a vote in anything. It'd be the interest that it was carved out of that would make those decisions.
That's correct.
Just for my understanding, can you give me an idea of how a production payment differs from an override? That's the first time I think I've seen production payments. So I'm just
There may have been a conveyance where they just account for, a certain dollar amount or a certain percentage of a payment or revenue payment to go to a different party.
Okay.
It's not an
Just a
actual
different kind of-
ownership. It's a contractual ownership rather than a real ownership.
And then this might be something your engineer will address, but when I look at Exhibit B and Exhibit C, I do think there's a discrepancy on Exhibit B. So if you look at the first page of Exhibit B, if I can find it in this thing.
You said Exhibit C, correct?
Exhibit B and C. So Exhibit B is the multi-page exhibit, and Exhibit C is blessedly a small one-pager.
Yep.
The tract 1 participation factor indicated on Exhibit B does not, so not just track 1, but phase 1. Phase 1 in all the tracks in Exhibit B. That participation factor doesn't align with what's presented on Exhibit C. And I guess it would appear to me in looking at it that the numbers calculated for the phase 1 working interest and NRI percentage tracks didn't use the value on Exhibit B, but used the value from Exhibit C. So I'm just like,
Exhibit C is based simply on surface acres. That doesn't take into account any of the reservoir allocations. The phase 1 track participation factor on Exhibit B includes all of the allocation factors from the phase 2 formulas.
okay. Then it appears that, at least to me, when I'm looking at it, the phase 1 working interest and phase 1 NRI columns on Exhibit B may have been calculated incorrectly. If they were intended to use the phase 1 track participation factor off of Exhibit B, the math doesn't work that way. It looks like they used the number off of Exhibit C. And maybe, again, that's something the engineer can address if we're not sure.
Okay, we'll have to go back and look at that.
Okay. If you can address it during yours. I think that's all I've got for plan. Okay. Thank you.
Mr. Schmidt, please raise your right hand. You solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief.
Yeah, dude.
John, state your name for the record, please.
John Schmidt,
And John, by whom are you employed?
EOG Resources,
In what capacity?
as a senior geological engineer and operations. Thank you. Operations coordinator.
And in that position, have you testified before the commission on previous occasions?
I have
Many times.
many times.
And have your qualifications been considered that of an expert?
Yes.
Offer the testimony of this witness that of an expert.
Motion granted.
Okay, John, let's go to where Anna finished. She finished the L1 through L4 exhibits. Let's go to G1, and why don't you identify exhibit G1 and then briefly discuss what's contained upon it.
G1 shows a middle Bakken structure map with the dip to the southwest. The unit is outlined, or proposed unit is outlined in blue, and the wells that are drilled in the unit, currently drilled in the unit, are in yellow, and drilled and completed in the unit, are in yellow and then in purple. As Anna showed in her exhibit, there are 3 wells that at the time of filing had not yet been completed, but now have. But those are addressed. Right, those are being addressed as a separate part of the unit agreement. There's a cross section A to A prime that goes from the Erie well to the Ross 717 well to the Juma well, and then those wells are then shown in Exhibit G3 in the cross section. Dip to the southwest, and obviously the Middle Bakken is present. We've drilled in it, 35 wells in it in the area.
Okay, then let's go to G2.
G2 then typical structure map for the Three Forks Reservoir in the Bakken Pool. Again, blue outline for the unit. The purple wells are the Three Forks wells that have been drilled. 8A prime is the cross section, and dip to the southwest, and obviously the Three Forks is present. Three Forks First Bench is present. Three Forks First Bench and the Middle Bakken member are the 2 targets that we will be drilling in this case. And so that, I think that takes care of G2.
Okay, and G3.
And then G3 then shows the cross section, that 8A prime cross section with the Erie well, the Ross 717 well, and the GMO 1-1-10 well. The KB to address your earlier question about the KB, from IHS, we got a number from IHS. In IHS, it's 2460. If there's a discrepancy, we're happy to go to whatever the commission deems is correct.
Okay, and Mr. Suggs can ask you more questions about that as you
Okay.
finish up. Go ahead.
And then, so on that, we, like I said, we show the primary contributing interval, and these are the intervals that we based our oil in place calculations off of. That would be the Middle Bakken member and the First Bench of the Three Forks. Because the shales are very low perm, we believe in the case for near-term production that they would have little contribution, and then because the second and third bench are high in water saturation, we believe they would have limited contribution. That's why we're going to target Middle Bakken member and the First Bench for this area. So we use these wells plus one other, the Cooster 14-17, which is just to the northeast of the unit, in building our petrophysical model. And from our petrophysical model, for the Middle Bakken, we had H's that varied from 30 feet to 62 feet, fees from 6.9% to 7.5%, SWs 0.2 to 0.43, and our SOPH value for the Middle Bakken 1.54 to 2.88. There is a lot of variability. You would look at that and say 30 feet to 62 feet for H in the Middle Bakken. If you look at the Ross 717 well, that's the one that's 62 feet. And you can see that there is quite a bit of variability, and some of that is due to the presence of the shoal facies, the oolitic. And when I steered these wells many years ago, Alan Gathridge, our mudlogger, would say, "Hey, we hit the shoal." So it's that clean nick in the top third of the Ross, and sometimes that can help cause an expanded amount of the Middle Bakken section in the Middle Bakken member. So that's why there's that much variability, and those shoals do come and go. So that's how those are the Middle Bakken attributes that we used in building our petrophysical model for the Three Forks first bench. Height is almost uniform, 32 to 34. V 0.8 to or 8.7% to 7.8%, SW 0.31 to 0.44, and an SOVH of 1.5 to 2.01. All these numbers go into our petrophysical calculation. That SOVH, as it varies across the unit, goes into our petrophysical calculation for the oil in place number that we use in our ensuing calculations into the track factors. I think that's it on the geology side.
Okay. You were involved in selecting the proposed formula for this unit, were you not?
Yes.
Okay. Let's turn back to the unit agreement. I think it's section 12 of the unit agreement, which is on page 8 of the unit agreement. And what I want you to do, John, is briefly describe for us the parameters that you utilized, or that EOG utilized, both in phase 1 and in phase 2.
Okay. So phase 1 has two components, and phase 1 is what we're going to do in phase 1 is account for the existing wells and their production, how much they produced, how much they have left to produce, and then attribute that across the unit on a per track basis. So to do that, there are two parts of that. We attributed or weighted 90% of it to essentially the estimated 90% on the ratio of estimated primary reserves as of August 1st, 2025. So we used up until the production data.
Let me stop you for a second. You said to estimated primary reserves. It's estimated remaining primary reserves.
Yes, that's correct.
Okay. I'm sorry to interrupt you.
No, that's fine. Estimated remaining primary reserves as of August 1st. So we used the data so we based our EUR plots and our cumes based on the cumes of the wells up to the July data, because that was the most recent month that we had when we filed for the petition for each, and continuing on for each of the wells drilled, completed, and producing proportional to the footage within the tract within the unit area to the total estimated remaining primary reserves as of August 1st, 2025 for all the wells drilled and completed and producing within the unit area. So what we did was we took the EUR, subtracted the cume, whatever was left would be the estimated remaining primary reserves for each well, and then we attributed that, because some of these wells touch more than one section, we attributed that on a per lateral foot percentage to each of the so if a well had 50% in one section, 50% in another, the remaining was attributed or allocated to the two tracts that it was in, and then the sum of all the wells in each tract, or percentage of each wells in each tract, was then put into a total. So that's the producing well component in phase 1. The 10%, the second part of phase 1, or sub letter B, we based upon 10% of the surface acre ratios in each tract to the total surface area acres for all tracts within the unit area. So that's just whatever the acreage of the tract is divided by the 12,000. What's the number? 14,029.39, I believe. So so we got a 90%. 90% was weighted to one average. are weighted to that, 10% to that. That's for phase one. So then for phase two, we we were wanting to how to disperse equitably future production from any new wells drilled, and to get that so I will read the legal description, and then I'll tell you the math that we did, if that would suffice. 100% upon the ratio of remaining primary reserves as of August 1st, 2025, and that again is because we picked a cutoff date and went to that. For each tract, less the estimated remaining primary reserves as calculated for phase one for each of the wells as described in phase one, in total estimated remaining reserves as of August 1st, 2025 for all the tracts, less the total remaining primary reserves as calculated for phase one for all the wells drilled and completed and producing within the unit area. So for that, basically, to get that ratio, we ended up with the way we went about that was we came up with an oil in place number per tract, and that comes from the tract size times the SOPH divided by the formation value factor B sub O. We then multiplied a recovery factor, what we think is reasonable from those the OOIP was calculated from the main contributing intervals, which I had mentioned before are the Middle Bakken number that we use for the calculation and the Three Forks first bench in the Bakken petroleum system. With that, we multiplied the OOIP by the recovery factor, and then we subtracted out the EUR to get an OOIP per tract. Then we subtracted out the EUR per tract that was attributed in phase one, and that finally gave us a ratio. And then we took the remaining oil in place per tract divided by for each tract divided by the sum of all the oil in place, remaining oil in place per tract, the sum of the unit. So that is a long way of saying basically where we did the calculation in a spreadsheet, but what I'm trying to get you to picture is that we think that is appropriately attributing the currently producing wells through the phase one calculation and the future wells through the phase two calculation. So getting going, if you then go to Exhibit C.
Well,
Okay.
yeah. Let's. What I want you to do. No, you're fine. You're a little ahead of me, but I'll try to keep up. You've described now how this would work. I think it would be useful, and I think that's the direction we were going, if we were to go to Exhibit C of the unit agreement. And I don't want you to walk through every tract, but perhaps a simple tract. And let me get there to Exhibit C. And maybe we use tract one. That's section 21, township 157 north, range 92 west. It's comprised of 640 acres. And then you have a phase one tract participation, and you have a phase two tract participation. Can you walk us through then all the, you explained to us the parameters in the formula. Now walk through just tract one, how those calculations were done on your spreadsheet.
Okay. So for tract one, which is essentially section 21, we obtained, like I said, through calculating the remaining recoverable reserves in each tract. We did that on a well by well basis, on a footage basis. So once we got that number, for the tract, the allocated remaining EUR per section was then attributed up. So that number is 13,136. That EUR remaining in tract 1, and then that was divided by the total remaining EURs of all the tracts at being 1,750,000, 50,147, and I'm doing the math in the spreadsheet. I do have, would it be we came up with 0.75 for the phase 1 remaining primary reserves, and we weight that at 90%. 0.75 for the remaining reserves, and we weight that at 90%. Then we take a land component, which is 640 acres, divided by the 14,029, and we weight that and that comes out to be 4.5%, and we weight that at 10%. And when you add the two together, you end up with the 0.01131692.
Okay. And now, just very briefly, since you've gone into a lot of detail on phase 1, describe how you handled phase 2.
Okay. Phase 2, then we get the oil in place, which for track 1, section 22 or 21, we calculated at 12,245 or 12,245,000 barrels approximately, and then the remaining the EURs for the total EURs for that section 21. When we used the total EUR, it was 132,453. It was just from one well, so it makes the math easy, and so then that gives us a calculation. And so then we take the oil in place times the recovery factor, which I said was 11%. We multiply or then subtract. Then subtract out the EUR for that tract, which was 132,000 barrels, and then you divide. That gives you a remaining recoverable oil per section of 1,214,000, and to get the phase 2 tract factor, you divide that. You divide the remaining recoverable oil per tract by the total of all the tracts. So essentially, you get a remaining recoverable oil per tract, and divide it by the total to get a factor for the phase 2 tract factor.
And what do you?
And that for that is 0.048621196.
Okay, I'm sure there's going to be some questions on that. So let's move on, and let's go to Exhibit E1. And as you've done with the geologic exhibits, I want you to identify Exhibit E1. I'll let you get there.
Okay, sorry.
No, you're fine. I'm moving along here quickly.
Okay.
I apologize.
No.
So identify Exhibit E1, and then summarize what's contained upon this exhibit and why it's important to today's hearing.
Okay, E1 is our proposed development of the unit, with obviously the unit outline in blue. Our proposed pads starting at the south in section 16. As Anna explained, we have 3 wells coming off there that just came on production on November 4th, and so that's that would be our pad number 1. If you then go to the northwest, the pad in section 6 is pad number 2. Section 5 has pad number 3. Section 34 has pad number 4. Section 4 has pad number 5, and section 10 has pad number 6, and then their final pad is in section 17. And so the ability to eliminate the interior, not have the DSUs and the patchwork, allows us to have more flexibility and to drill longer laterals. We're planning on drilling 28 wells total. The blue squares, pads 1, 3, and 5 would be CTBs. The central tank battery, other wells would flow, other pads would flow to those. And I'll get into this. That's goes into our cost savings on it. And for our development plan, as I said, we drilled 3 wells off of pad number 1 in section 16. In 2026, we're planning on drilling 11 wells off of pads 2 and 3. And like I said, pad 2 will flow to us.
Let's hold off on that. I want to have you discuss that with our plan of development.
Okay,
So
sorry.
let's go on to exhibit E2. Tell us what E2 is.
Okay, E2, then it just goes into the in E2 and E3 then go into the cross section. So E2 is the red cross section, our wine rack view of the reservoir, what's been drilled, and what we plan on drilling. And as you can see in E1, we are planning on doing wellbore crossings. So the southern half of the unit doesn't lend itself as much because of the existing development to wellbore crossings, but the northern half of the unit, being more open, does allow itself to some straight north-south or eventually north-south wells that do cross some of the existing wells. So the E2 shows that cross section and how it would be portrayed in a wine rack fashion. E3 then is the same thing, except on the green line, showing the relative position of wells in the Middle Bakken, existing wells in the Middle Bakken, and existing wells in the Three Forks versus what our plans are along that along that section line.
Okay, and then what's E4?
E4 then shows a typical wellbore diagram, showing that for a 19,000 foot lateral, we do cemented liner with approximately 84 to 89 plug and perch stages.
Okay. Now, we don't have an exhibit for this, but I would like you to describe for us what you believe are the advantages of unitization. Even though it's not a secondary recovery project, it's a primary recovery project. What are some of the advantages of unitization?
So, first big advantage, no interior setbacks, so that allows us to have more flexibility on our well paths, drill longer wells, which we have been extending our well length from 1 mile to 2 miles to 3 miles, and now we're doing right at 4 or 4 plus. So it allows us flexibility in planning well paths, and we think this is the design we've come up with, as shown in Exhibit 1, is the most efficient way to develop the undeveloped white space in the area of the unit. No interior setback, maximize well length so we can drill cheaper and add to the economic viability. We're able to consolidate facilities. Like I said, we'll be using essentially three central tank batteries and flowing in each or one pad to pad number 1 pad or 2 pads to pad number 3, and 1 pad to pad number 5. And so this gives us essentially four fewer facilities because we're those satellite pads flowing, and when we're doing that, it basically saves us $1 million a facility. For times 4 would be approximately $4 million. The other thing that drilling these longer laterals allows us to do is up in that northern area, there is a extensive overlay. It kind of gets into Kettle Lakes up there. It's more, the southern area is more farmland. The northern area, and this is part of my planning duties, the northern area has a lot of little Kettle Lakes and wetlands, and this allows us to essentially put well bores on the south end of that wetland corridor and drill up under it without having a presence in the north. At one time, we had looked at doing east-west wells, say from section 21 into section 23, and that was deemed, finding locations up there and then getting pipelines to them was deemed, it was going to be very difficult. And so we had gone to DSUs and with this diagonal and then northern approach, north-south approach, now we've come to the unit where it makes it even more palatable from a surface standpoint to do it. We also have, as we've discussed in one other case in this area, there are Air Force cables going along here. So any of the pipelines that we have to do, if we can consolidate our pipeline footprint, it helps with that, with wetlands, with everything. And at this time, we have a surface use agreement for the 3 pads, or for pads number. Obviously, we have pad number 1 because we have drilled off of it. We have surface use agreements on a single landowner for pads 2, 3, and 4, which will be our next pads in the development. And I think that's pretty much it for kind of our cost savings and the advantages.
So you're thinking in the neighborhood of $5.5 million in cost savings by fewer pads and fewer facilities. Is that correct?
Correct.
And one of the reasons you'll have fewer facilities is you don't have to deal with that issue with the Bureau of Land Management having to do with commingling. Is that correct?
That is correct, because there are federal tracks within the unit.
And another very obvious advantage is no more applications for increased density, no more hearings for increased density, no more orders for increased density.
I might save a couple of $1,000 in airplane flights coming up here,
Okay.
but
Might
so
have an impact on your frequent flyer.
there you go. I might not get as many frequent flyer miles, but and so with that, those are what we see as the advantages in forming the unit for our operations side of things.
Let's go on to a little bit, and I cut you off, and I
That's
apologize for that, but I want to talk about the plan of development, and I wanted to keep that separate
Gotcha.
from your previous discussion of your engineering exhibit, which I think was that E1?
That's correct.
Okay, let's go back to E1 now, and let's talk about your plan of development. And what I mean by plan of development is if this application for a primary unit is approved, what will EOG do in the next year and the subsequent years in terms of drilling wells and developing this area as a primary unit?
Okay, so our overall plan, we end up with 7 pads, 3 CTBs, and 28 wells. That could go up or down, maybe by 1 well, depending upon how dense we go in this northern tier and how we see the original results. But right now we're planned at 28 wells. So those 28 wells would be drilled in this chronologic or time scale. We drilled the first 3 wells from pad number 1, and again, I'm sorry I didn't have them labeled on the initial exhibit 1, but again, pad number 1 is in section 16, pad number 2 is in section 6, pad number 3 is in section 5, Pad number 4 is in section 34. It's right at the border of 34 and 5. Pad number 5 is in section 4. Pad number 6 is in section 10, and pad number 7 is in section 17. So,
So it just to generally describe what you just is, you kind of go in a clockwise position, starting with number 1, which would be the 6 o'clock position, and then go around clockwise with number 7 being down in the lower southwest quarter.
That's
or
correct.
Southwest section, I should say. Okay,
That's
continue.
and so from pad 1, we drilled 3 wells. It will also be a CTB for pad number 7, but I'll get to that. In 2025, we drilled 3 wells. In 2026, we're going to drill from pads 2 and 3. Pad 2 will flow line to pad 3, a CTB on pad 3, and we'll plan on drilling 11 wells. In 2027, pad 4, we would have approximately 5 wells coming off of it. That's in 2027, 5 wells. 2028, pad number 5, which is 3 wells, the 3 easternmost that go north-south in sections 4, 35, and 20 and 23, or 20, yes, 26 and 23. And then pad 6 fills out the northeast corner in that undeveloped portion of section 31, and it will flow line to the CTB at pad 5, and then the final pad would be pad number 7 down in the southwest corner, and it would flow line back to pad 16. You'll note that we do have we got creative, and we think we can do it. On pad number 6, we've got what we would term a J well, and then on pad number 7, we also have a J well to try and get into that what we would consider untapped reservoir potential in the far southwest corner of 18. It helps us avoid drilling a short well, and again, maximizing well length.
Just some concluding questions now, John. In your opinion, is the unitized management, operation, and further development of the proposed Elger, Bakken, Ross unit reasonably necessary in order to effectively carry out the primary recovery operations you have proposed?
I believe so.
And in your opinion, is the proposed unitization of the Elger, Bakken, Ross unit feasible? Will it prevent waste, and will it, with reasonable probability, result in the increased recovery of substantially more oil and gas from the proposed unit area than would otherwise be recovered?
Yes.
And in your opinion, is the estimated additional cost of conducting unit operations for the proposed Elger, Bakken, Ross unit less than the value of the additional oil and gas that will be recovered?
Yes.
And then finally, in your opinion, is the proposed unitization of this unit for the common good, and will it result in the general advantage of all owners of oil and gas rights within the proposed unit area?
Yes.
Mr. Examiner, that's all the questions I have. We would offer the exhibits.
Exhibits are admitted.
And I do want to address the exhibits for 32368 after the questions on 32367.
Okay, the exhibits that you just offered are admitted. Before we take questions from the staff, why don't we take a 10-minute break?
Great, I can use the water.
So said he was gonna.
What's that?
I thought he said he was gonna recall.
We are back on the record.
I was going to ask you questions first.
And
Oh, okay.
Attorney Bennett, you can proceed. We're back on the record.
Yeah, I've concluded my.
All done? Okay.
Yeah.
Questions from the staff?
We're still going to address this, but I
Yes.
thought yes.
Guess we'll go with questions from the staff.
Yeah, I have a couple of questions. First, I'd like to maybe recall Anna for a question or two, and then move on to John. So Anna, and maybe this is for Lawrence, I think he's the one that discussed it, on page 15 of the unit operating agreement, Article 11.8, it says existing non-consent interests. And Mr. Bender explained how it coincides with the decision that the commission had made, but when I read this, it doesn't seem that it reads that way.
What page are you on?
Page 15,
Of the unit operating agreement?
Article 11.8, and in the fourth line it says payout balance has been satisfied out of unit production attributable to the affected tract. So to me that reads that it's not going to come from the entire unit.
I could see how you might take that interpretation, Mark, but the intent was to treat it as the commission treated the non-consent interests in the, I'll just refer to it as the Liberty case, and as was affirmed by the District Court and the North Dakota Supreme Court. But I will admit that this language could be better clarified, and I'll submit a suggestion for a change.
Okay. And then in the COPUS agreement, Exhibit E, the agreed upon or the agreed interest means it's, and I'll paraphrase, means it's the prime rate published by the Wall Street Journal plus 3 percentage points. Am I reading that correctly?
I'm sorry, what page are you on?
It's on page 1 of the COPUS. And it's the agreed interest. And as I paraphrased, it's the prime rate plus 3 percentage points. Am I reading that correctly?
That looks correct, yes.
The commission in the past, and we can re-examine this, but has typically restricted that to the prime rate plus 1%. Is that an issue for EOG?
No, I don't think we would be opposed to that.
Okay. And John, I just have a couple of questions for you. You talked about how you calculated the original oil in place, and then you applied a recovery factor.
Mhm.
Is that recovery factor the same for every tract, or is it individualized?
That recovery factor is the same for every tract. And what we did, if you'll go to come up with that recovery factor, what we did, if you go to Exhibit E1, down in Section 10, there's an infill package that we did early on, and we calculated based on the EURs from that package and the surrounding wells, and putting an area over it, we calculated what the recovery was from the wells in that area of interest, and we think that that is applicable to the entire that this is what we're going to see when we infill at a deeper or greater density for recovery factor in across the entire unit. So that's why we used one.
It was 11%, I think.
11%, yes.
And if that recovery factor, if it was 15%, does that affect anything because it's going to be applied equally across the unit?
It's going to be applied. It would be applied equally across the unit.
So
correct.
it doesn't really matter what the number is.
I think it has to be realistic.
Oh yeah, but I mean,
yeah,
if there's a difference of opinion,
yes,
small percentage, it's not going to make any difference.
not substantially.
This is maybe just a forewarning. Obviously EOG has proposed a unit name. I don't know that, I guess I haven't looked at it that closely as to if the commission believes that's appropriate, but if the unit name changes, does that matter to anybody, to the federal government?
How do you feel about it?
As long as it's addressed the same in all the documents, the same in the order as it is in the order, I guess there would be an amendment. We don't. The unit name is.
I can tell you how the unit name, we came up with the unit name, and then tell you what I think about a change. As you know, the unit area overlaps two fields. I think there's more in Alger than there is in
Cottonwood.
Cottonwood. So we selected Alger as the first name. It's obviously a Bakken primary unit, so we selected Bakken. And I believe Ross had to do with the township. And as you know, the commission has considered some other units where it's been a partial portion of the field. And the commission used to do things like, north, south, east, west, northwest, southwest. We tried to stay away from that and just try to come up with something like Ross. But if EOG doesn't have any problem with the name change, I think that could be done very easily in the commission order and say that the unit is going to be called this.
The plan of development. I think it's important in these types of units, and any unit, I guess, to have a plan of development for the acreage. And then you talked about the advantages that you enumerated. I guess I'll just ask maybe an obvious question. Why wasn't that submitted as an exhibit?
I guess it was. I should have put the by year. I submitted the well bores. I should have put a time frame to them. I'm sorry. I
didn't know if there was a reason.
You can submit it as a
Yeah,
supplement.
I'm going to ask for a supplement on.
I agree with you, Mr. Poor, that it's in the record through verbal testimony, but it might be a lot easier for the commission to follow the plan of development if it's in an exhibit. And there might be some other things that were testified to verbally. So the evidence is in the record, allowing the commission to render a decision. But if the commission finds it's easier to evaluate the information, we're happy to put it in the form of an exhibit.
Yeah, I think it would. So basically an exhibit discussing the plan and pace of development. Maybe amend exhibit E1 to enumerate the pad numbers on there.
Something like this.
And I think also a supplement exhibit enumerating the advantages that you're going to realize if this unit is formed.
Okay. Yeah, I'm happy to. I'm also in conjunction with that. Can I have an exhibit showing the wetland issues?
I think that would be
It
helpful.
would be appropriate for the operations and development. So
it all fits together.
okay. I apologize. I'm used to doing it on a DSU by DSU basis, and we're always waiting for that next DSU order to come in so we can go drill it. So I will know for the future. I apologize.
All right, thank you.
I have just a couple questions. Anna, on page 17 of the unit operating agreement, Rich touched on this as well. It's the unleased interests, 14.1. I'm curious as to the 1/8 interest on the royalty. Is that a standard in the area and today that's being utilized in this type of a situation?
Typically, when an unleased mineral owner is non-consent in a well, the royalty is 16%.
Okay. Is it something that? So in this paragraph, I guess it states that it's 12.5. Is it something that EOG would consider to modernize this to more standard industry royalty interests?
I think this is more in line with the federal leases.
The federal leases. So you've aligned this with that of the federal leases. Okay.
I'm sorry, Mr. Director, I missed the question. What is it that you want to consider modifying? I
So
apologize.
the 1/8 on page 17, under treated as leased in section 14.1, Rich touched on that.
14.1, you said, of the unit operating agreement?
Yes, on page 17.
I apologize for making you go through this.
That's okay.
Page 17.
Yeah, the question was, is the 1/8 the industry standard today in the area?
Okay.
And I guess what Anna indicated
Thank you.
is,
I thought that's the direction
Okay.
we're heading. Paragraph 14.1 is directly out of the statute.
Okay.
The statute in North Dakota having to do with the unitization says if you have unleased tracts, they are to be treated as a 1/8 with respect to royalties and 7/8 as respect to working interest. I would add to that is that if we have a situation where we have an unleased tract and under the porous pooling statute, they are to be treated as the acre weighted average or 16% at the election of the operator. Once this unit is formed, that is going to switch, and those royalty owners will go from 16% to 1/8. But there's nothing we can do about that.
Yes.
That's what the statute requires.
Okay.
So, apologize for not listening carefully
Okay.
enough to begin with. So,
Anna, on the COPUS section, so I guess it's Exhibit E. Can you briefly explain what this document is and how it impacts everyone that's
Yes,
involved in agreement? And there's throughout this document in several places there's numbers typically that are highlighted in red. And I don't need you to go through every one of those, but can you explain what those red numbers generally are, what the decision is around those?
So the Exhibit E is the accounting procedures. So it details or outlines all of the procedures that will be taken when they do all of the accounting. The numbers in red, thank you, are numbers that we have filled in the blanks typically, and we put in, various costs for different items that we would be charging for, overhead charges, producing charges, things like that. These are just where we filled in the blanks with the market rates at this time.
Is the same set of COPUS standards utilized for every the entire unit? So if an interest owner wants to negotiate differently than what's been agreed on by the other, whatever 20% or whatever the number is, it has to be the same throughout the entire unit, or does it change? Can this change per interest owner?
No, this will be uniform over the entire unit area.
Okay, so I think 55% that has to agree, 55% will agree to these COPUS accounting standards.
Yes,
And
correct.
and those items that EOG has placed in there is the red highlighted.
Yes, this has
numbers
been
typically.
provided to all of the owners.
Okay, thank you.
and Mr. Director, if I could maybe add to that a bit, before the Bakken, as I'm sure you well know, oil and gas companies would propose to drill a well, and they would send out a joint operating agreement. And attached to that joint operating agreement was a COPUS accounting procedure. And then we got into the Bakken, and nobody used JOAs. And all these wells are being drilled based on forced pooling statutes in the state of North Dakota. When we come to unitization, we're back to, in essence, a JOA. And now it's not called JOA, it's called an operating agreement, but it's an operating agreement approved by the commission, and that operating agreement has an accounting procedure, and that is the COPUS.
Yeah.
So we're, in essence, reverting back to back. And if I'm telling you things you already know, I certainly
That's okay. I appreciate the dialogue on it. I think it's important to just make sure that it's known and of the record that this same agreement is utilized on every interest owner across the unit, and that the majority agrees to this. Going into that. Got a couple other questions. Let me look here. John, on the, is it possible? First of all, I appreciate the exhibits. Is it possible for EOG to submit a map showing the surface impacts that would have occurred and therefore have not occurred because EOG has moved their operations to the south in an effort to protect the wetlands and the natural resources of North Dakota? And so I guess what I'm thinking is some type of a map exhibit that just shows those the areas where you had, I think, testified that you had considered trying to build paths in the future versus where you moved them now, in the positive impact that actually has on the natural resources in this area.
Yes, that was mostly in the northern half, but yes, that I can submit showing I guess an exhibit showing a map with paths that are no longer going to be used and pipeline routes that would no longer be used due to us unitizing and drilling longer wells from essentially the center.
John, I might suggest that you incorporate that into the exhibit that Mark asked for on addressing the benefits of the unit.
Okay.
And then, John, sorry, go ahead if you need to take a note.
No, I got it. I'm ready.
You explained in decent detail about your what I would call, and I just want you to confirm if it's true, that this is a reservoir quality based allocation method rather than just a surface acreage or mineral interest acreage allocation. Can you submit the formula? I believe I didn't get it for phase one, but I wrote it down for phase two, which is the oil in place times the recovery factor that Mark asked. Okay, you have that?
Yes.
Okay. Is there? Can you submit that?
Certainly, it should have been submitted. I like I said, the first time doing one of these,
That's all.
and I started seeing the holes in the things that I was going to need to help paint the picture adequately, and so I have one almost.
Yeah, it's all good. It's my first time on a large unit like this. Anna, on I think this is the state lands map, whatever the federal and state lands map. I'm not
Exhibit A.
exactly sure. Yeah. Are the blue hashed lands, are those all state of North Dakota lands?
Yes.
And are they trust lands, or is all of that North Dakota trust land,
Yes.
or is there other state lands that are involved in this map?
I believe they're all
They're all trust lands.
trust lands. Yes.
And what's the process there? Do you guys work with trust lands?
They were notified of this hearing and of the unit information. We've actually been in touch with them, and they seem inclined to sign the ratification at this point.
Typically in the past, too, the Department of Trust Lands will reach out to the Geologic Survey for some assessments, too. So
Okay.
I think that's happened.
Okay. I have the same request of the development schedule that Mark had, so I won't repeat that. that's it. Thank you.
All right. I'm gonna, I guess, take that request from Nathan regarding the formula and ask you to expand on it a little bit further.
Okay.
Give me a whole show your work type exhibit. My understanding with your testimony is that you actually did oil in place calculations to start with, right?
Correct.
So if you could give me
For phase 2.
for phase 2, but if you could give me the information, the maps that you use for porosity across the spacing unit. I know you gave me the ranges and the numbers, but if you can give me the information to validate that.
Yeah, I've got an SOPH per tract that we could, that if that would suffice.
That should be sufficient.
Okay. Because I mean, you had to average it across the tract and come up with a number, and then obviously it's an SOPH for the Bakken and SOPH for the Three Forks, and then it's additive of the two. So I have that additive number.
Do you have the maps that you used, or do you have the SOPH presented on the Bakken and the SOPH presented on the Three Forks? I know you just said added them, but do you have a map of each of them?
I don't have a map.
Numbers per tract.
Yeah. If
How did you do the oil in place calculation in general?
we worked it into our proprietary petrophysical model, and so I think we're okay with giving the SOPH numbers. We prefer not to give the map.
Okay. I am going to ask for at least those.
Okay.
And that's done on, you have that at a track by track basis as well?
Yes, correct.
Okay, so I definitely need to see that.
And I can speak to the fact that our SOPHs are lower and you saw that in the cross section, that the further north you go, if you go back to the cross section, you're a little bit thinner up there. You start to see more of the oolitic shoals down in the south, and therefore the H component of your oil in place calculation is greater, has more effect on the SOPH constant, if you will. And so, I mean, I can give you right now the range of the SOPH is like in the 3.29 to 3.336 all the way to the north, and we get down into the 3.97, 4.08 towards the south. So we do feel the reservoir is getting better, but our track factors account for that in the oil in place, the original oil in place number for the track factor awards the better reservoir to the south with that SOPH and oil in place calculation.
Right. I just need to be able to verify that your numbers going into those participation factors seem within reasonable range of what we come up with if we did them. So I need to have enough information of how you got there, to kind of semi-replicate that operation.
Yes.
So if you could provide, I think it's more than just your SOPH map, or not map, but numbers. If you could give do you happen to have like the porosity and water? You gave us the ranges. Do you have those also on a track by track basis? Water saturation, porosity.
I'll work with our team to get.
If you could give me like almost a tabular exhibit that went by.
So if you had the components of the oil in place calculation on a track by track basis, then so you can recreate the math.
Right, that gets me close.
Fair enough.
While we're on that topic, I'm going to ask for something similar for how you did phase 1. The wells, if you can give me a tabular exhibit of the wells, the footage attributed to each of the tracks for each well, because then we can sum them up per tract, as you indicated you did them.
I have them in a spreadsheet, and I can make them available in tabular form.
Okay, so an exhibit that lets me get to how you did phase one.
Yeah.
So show your math exhibits for both phase one and phase two.
The second part, the part B of phase one, is just it's just a straight acreage calculation
Right. That's
times
fine.
the 10%.
That I understand. It's,
Okay.
it's the rest of it I need to make sure.
Yep.
We can
Fair enough.
confirm are reasonable. And I guess while I'm on, while we're talking about phases, I'm going to get myself all out of order here, but I don't see in the unit agreement where the phase one, phase two trigger happens. Or do you start paying out on phase two as soon as the unitization happens? Or
That was my understanding. It's that we start as soon as the unit is agreed to the participation factors then go into effect. The phase one is attributable to all the wells, the producing wells, the roster of 35 wells, one being P&A already, the James. So in the list of wells is in.
there's an exhibit, I saw that, but let me pause before you go further with that. Is your intent that the existing wells pay out per what is listed as the phase one, and all future wells pay out per what's listed as phase two, or because that's what I caught just now is that it sounded like, but
My understanding is that there would be a phase one where
up into it.
current production and future production would get paid out until phase one, until you reach this point. Now, I don't know what that point is.
But that's what I'm
And
getting
that
at.
goes
then.
into phase two. I pulled this formula from another application, and there was no conversion there from phase one to phase two that I recall. But I think we can go back and look at that and see if there's some logical place in time or logical place in the amount of production where we go from phase one, convert from phase one to phase two.
Yeah, typically it would be some number of production
Yeah, certain
that
number
would
of
trigger,
barrels.
right? That would
Yeah.
trigger the switch over. I don't see it in here. I don't know.
It's not.
Right. So
It's not.
I think we either need that or a better explanation of how, upon unitizing, where phase one gets paid and where phase two gets paid.
I'll talk with John, and when I think I better understand his formula for phase one, and I think we'll be able to come up with a number of when we reach a certain number of barrels produced that we would convert from phase one to phase two. Is that something we can work on, John?
Yes.
So we'll need a supplement on that.
Pardon me?
So you'll supplement the record with a
Yeah, supplement the record, and likely there's going to be some other changes to the unit operating agreement as along the lines that Mr. Bohr pointed out. So I think what we might even do is propose language in the unit agreement to address that issue.
So if that's part of it, I mean, then your supplemental
Yeah,
unit
exactly.
agreement covers it. Just, I guess, when you submit that, make sure you're clear what the changes in the supplemental unit agreement are trying to achieve. Just some bullet points.
Probably do it in red line, and then as well as an explanation.
Okay, so let me see if I have. So I guess I'm just going to follow up on a couple of things that KB elevation that was discussed a little bit. Everyone seems to be reporting 2460 as the right KB, which leads me to believe that the numbers in the unit agreement for subsea TV are just typos. They have an extra 2 feet in them.
Okay.
So just correct that, I guess, as well with your amended unit agreement. I said, I got myself out of order in how I was going to address some of this, so I want to just make sure we're clear. You gave us some testimony on the purpose of phase one in the formula is to account for those wells that have been drilled and the production that they've done to date, and how they would perform should no unitization. That's kind of your intent on what phase one was supposed to represent. And phase two was supposed to represent, again, I'm going to paraphrase what I remember you saying, effectively, when you start drilling new wells on the unit, making sure that even though phase one wells had paid out to their tracks, right, new wells would pay out accordingly and it'd be adjusted so it's equitable, even though they might not have, new well acreage might not have shared those original wells. When they share to those that maybe decrease slightly because of the formula accounting for the already produced recoverable.
Correct.
So with that in mind, I want to just look at your Exhibit C. And I'm going to use L2, I think. Yeah, L2 and Exhibit C. So if I'm looking at L2 and I look at tracks like, well, they're not labeled on here, so we might want Exhibit A in front of you too, but I'll do my best to keep us in line here. Track 6, 7, 8. Sections 6, 7, and 8.
Sections or track?
Sections. Okay. In the southern part.
Yep. And you're talking for phase, or
Phase 2 specifically here.
okay.
So I'll simplify this. Section 6 is track 17. So when you look at Exhibit C, track 7.
Section 6 is track 10.
Is track 10, sorry.
10, yeah.
Yep. And then section 17 is track 19.
Correct.
So I want to look at those two. Because if you look at L2, section 17 and section 6 have a number of existing wells. Maybe they're 50+% developed. Do you generally agree with that if I'm looking at L2 with all well bores are already drilled in there?
Yes, but the 3 that were just recently drilled
Makes it more
makes
more
it
like
appear
almost
more.
100%, right? So, but again, they've got more development. Those two sections would have more development on them than the rest of the acreage in general, right? I mean, I'd say 6, 7, 8, 17, and 10 probably have the most development,
I would agree with that, yes.
right? So, your attempt to attribute phase 2 allocation, I would expect, since they've already produced a fair amount of oil based on their existing development, that in track 2 they might have slightly lower participation factors than something like section 21 or 22 up in the north, which is track 1 or 2. I mean, general assumptions seem to make sense.
Yes, I see where you're.
So, what I'm getting at is I'm not 100% sure that I'm comfortable the phase 2 formula appears to be doing what you indicated it intends to do. Because when I look at the phase 2 participation factor for something like section 6 or track 10, it's 0.05. And if I go up into track 1, that's like 0.048. They're very similar. Like it feels, and there's a number of them like this. Some of them seem to align with what you were indicating. There are some of them that are lower. I think section 8, section 7 or track 14 appears to have a lower phase. It's 0.39 down a little bit further, right? So there are a number of them that seem to fit that pattern or that expected pattern.
I see what you're saying on it.
Is it a function of the reservoir quality part, the oil and place part that went into it?
There's more. Okay, I see where. So let's take tracks 20, 21 and 22, and 8 and 7, for instance.
You mean sections.
Sorry.
I get the same problem.
Thank you. Sections 21 and 22, or tracks 1 and 2, and sections 8 and 7, which are 14 and 15. Tracks 14 and 15. There's less reservoir, or the reservoir quality isn't as high to the north, but there's more potential because there are fewer wells.
Right.
Okay. And in the south, in section 7 and 8, there are more wells, but it's higher reservoir quality. So, it's a balance of the two, and that's what the formula takes into account. The formula takes into account production or EURs that are possibly draining in the south. It's knocking it on that, and then but it has higher reservoir quality. That's why they're about equal, is because the lower quality rock on the north has more potential reserves still. The higher developed stuff on the south has the higher quality reservoir on the south has already been developed.
I think I understand now. I think the missing piece in my initial evaluation was probably the oil in place calculation that went into it in the first place.
Yes.
So that's the importance of that exhibit. I think that'll allow me to validate that the numbers seem to be in line with what we would expect. So I think that'll take care of that. In your phase 1, determining your EUR, I'm assuming you used decline curve analysis on the existing wells?
Yes.
I think we're going to need to see a supplemental on that as well.
Okay.
Did you do it on all of the wells in the proposed unit, or just on a subset?
No, just we did EURs on all wells.
Okay.
And like I said, the cum or the cutoff was on,
And that's what went into the footage separation.
Yeah.
So then I think I probably need to see the decline curves and their EOR calculations on each of the wells, the existing wells.
Okay.
When you provide those, also provide the typical parameters that go into the decline curve. And then I already asked for the supplement with the footage per well separation. So
in tabular form.
yes. When you did that decline curve analysis and came up with their EORs, was there any consideration given for Middle Bakken versus Three Forks wells? Did they seem similar?
They seem similar, and we are forecasting them to be similar.
Okay, so effectively expect a reasonably similar result from Middle Bakken to Three Forks one.
Yes.
Okay.
And that can kind of be seen in the obviously we have a pattern. We were trying to do a pattern. If you look at E1, we're
Roughly
trying
alternating.
We're trying to alternate. It isn't the south with the diagonal wells doesn't lend itself, but as you can see from our recent drilling in 2025, the 3 wells we drilled, 2 of them were Middle Bakken, 1 was Three Forks. Some of that had to do with we have to start the pattern somewhere, and some of it I would say that we're fairly comfortable that the Bakken wells and the Three Forks wells are going to perform similarly.
Um,
Yeah.
and I think that plays out under E1. It looks roughly alternating. I get where you're saying
Yes.
complications, and it's not absolutely necessary by any means, so it makes sense. But back to the EOR evaluation, did you account for or did you adjust anything for changes in completion strategy through time? The initial wells being single 640s, older completion styles. Some of the infills probably were completed slightly different.
A little bit different, but no, because the older styles had a shot at virgin reservoir essentially, and so I think the completion is usually to try and go out and touch more reservoir. So I think it's applicable to that we didn't adjust for vintage because the earlier wells had a chance of having almost overpressured or touching overpressured reservoir. So I think it's amicable.
Okay. You've indicated plan to just target the middle Bakken and first bench of the Three Forks.
Correct.
You indicated second bench and lower was higher water saturation. So is it off the table due to those water saturations, or is there some consideration down the road that you might consider Three Forks?
I think it would be. It's oil price dependent.
Okay.
Anyway, the whole pool is being unitized, so I think there would be potential for future wells to be drilled. And being that we haven't drilled in the second and third bench yet, there wouldn't be anti-collision issues, and so we'd have more flexibility and freedom with well path delineation.
Yeah, drilling those wells would be easy enough. I guess my question comes down to because you haven't developed any acreage in the Three Forks 2, your formulas for phase 1 and phase 2 are designed around kind of balancing where you've had productivity and where you haven't. They'd be on an even playing scale or playing field. When you get down into Three Forks 2, you're probably not drawing much up into the existing wells at this point, right?
Correct.
So would it be appropriate to continue applying that balancing formula if you started developing in the Three Forks or deeper in the Three Forks?
I'm just going back to my Three Forks reservoir properties. There's less variation in the Three Forks than from north to south than there is in the Bakken from north to south. So I think we'd still be correctly attributing proportionality to keep the same formula in the second and third bench because of the uniformity of the Three Forks in the area. At this point, our plan is we are not asking to drill any second or third bench wells, and honestly, that's why it wasn't factored into the formula.
If you did consider drilling deeper in the future, do you think it'd be appropriate to consider amending the formula potentially?
I think that would be totally dependent upon the wells being considered to be drilled, where the geographic location of the wells being, and where in the unit it was.
Did you happen also to? I know you focused on the Middle Bakken and TF1, but did you do oil in place numbers for the lower Three Forks?
Not for the contribution calculations for phase 2 now.
But you have numbers for like an oil in place.
Yes, we have oil in place numbers for how you would segment out the zones. Yes, but whether that, I think it comes down to how much of that is movable oil with the water saturations we believe impede the Three Forks, the lower benches of the Three Forks.
Would you be able to provide an oil in place for the TF2 and the lower, and call it the lower Three Forks, on tract by tract, similar to what you have for the Middle Bakken and TF1?
Yes, we could come up with a number. Yeah.
I think I'm going to ask for that as a supplement.
Okay.
And I guess I'm kind of crossing over. In developing the formula that you're presenting for phase 1 and phase 2, did you consider other parameters that you worked with to try to come up with this, or is that kind of where you went and focused on that?
That's where we went and focused, and I believe it's a allocate a true allocation of the resources that have been produced, or been produced and are to be produced in the future. Our team has come up with that formula, or settled on that formula, because we think it's representative.
Okay. I guess returning to that questioning line that I asked of Anna regarding Exhibit B and Exhibit C, that discrepancy I pointed out.
It's not, or okay, yeah, if we could go to that. Yep. So in Anna's formula, if you go to that,
So
if you go to
first page of Exhibit B.
Yeah. So, in her formula, if you label that 0.75 number at the top A, and the 4.56 B, those are the two components of that track phase 1 track component. She's just using those numbers in her formulas in her spreadsheet. So, and the label, I think we came to the conclusion that the label, it's this 0.75 isn't the phase 1 track participation factor. It's the A subset of phase 1. Does that make sense?
A being the recoverable.
Yes. So if you take that 0.75 times 0.9, and then you take the 4.5 times 0.1, you come up with the 0.1011. It's in here. It's in her formula. The correct numbers are being utilized in her formula. The label on this one, on the top one, is just wrong. It was just to show that we were using that A component plus the B component. She was using it in the formula, so we can get it corrected so it appears correct. But we went back and checked the formula, and the formula checks out. It's just how her spreadsheet works with those numbers.
Okay. So when I went and tried to replicate the numbers calculated here, the phase 2 calculations worked fine when evaluating against the phase 2 track participation factor listed on the exhibit. It was just the phase 1 numbers didn't seem to align with that 0.75 number. So that's that 0.75 number would that actually be the
It's 0.75%.
percent? Sorry, but would that be wouldn't it be the part B or the acreage part if you're because the recoverable seems to align with
So we have
Well, maybe just to avoid further confusion in the testimony side of this, go ahead and supply a supplemental explanation and maybe correct that value, but give us an explanation of where it comes from and how it's being used.
Okay.
Yes.
Because again, ultimately, I need to make sure that what you're presenting here and what you're using fits and seems reasonable.
Okay.
I think it's pretty clear, but on your G1, I'll just confirm. The legend on G1 has first bench and second bench.
Yeah,
Three
they-
Forks
they're-
indicated.
we're
No
not,
Three Forks.
We're not doing
Yeah, no Three Forks second bench exists today,
correct.
and nothing was planned or indicated on any of the supplementals. I just
No.
wanted to make sure there wasn't.
No,
something
where our
missing.
plan is for first banks Three Forks.
Okay. And then when you were talking about your exhibit E1, you pointed out a couple of your alternative wellbore designs, J-shape or U-shape type
Yes.
lateral. Looks like you're currently planning for 2 of those.
Correct.
Has EOG done any U-shape laterals anywhere, or would this be new for EOG?
It would be a new thing for EOG. We've obviously had some laterals in the main field where we've had severe dog legs, and we've been able to do that. We've had wells where, particularly down by the lake, where we're limited on surface position, where we swung out and did a fairly substantial, almost 90-degree turn in the lateral. So we're very comfortable that we think we can make that work. Obviously, those 2 laterals are 2 of the shorter distances, but you add in the hook and it gets you into the 15,000 to 18,000 foot. But we're very comfortable in that. And we also have drilled U-shaped wells in the Delaware Basin, in Delaware Basin, but we have not drilled any in North Dakota.
Okay, so you've done that style,
Yes.
just not here.
Yes.
Okay. When you complete those wells, do you do anything different with your stimulation, say around the curve, where you're close, or where you're approaching the boundary of the unit? Any plans for changing that up?
We would have to obviously stay. That would be considered a most parallel leg. So at that point, we would have to be 500 feet off the closest boundary. I think we would. It looks like that in that one in particular, it would be the north line. And of course, there's we talk about the one on the east, and there's an offset. Let's just say the south line of section 36. How about that with the township offset? And then on the west side, we would be 500 feet off of the west line of 18.
So internal to the unit, you would apply the same restrictions that we would do on a spacing unit type basis.
Correct. As we approach the unit boundary.
If anyone else has questions, feel free to jump in. I'm just verifying that I hit all of my scribbles. I think that is all I had direct questions on. I will note that we did ask for a number of supplementals. If
Time is of the essence.
so, you'll work to get those in the
Yes.
short term. If anything's unclear in those, and we have questions or need to follow up on those, how would you like us to proceed with that follow up?
Just contact me. And I think it might be appropriate, Mr. Suggs, that we provide a list immediately after this hearing and submit it to you and say, this is what we understand you want. That way, if that triggers something additional you want, you can ask for it rather than waiting for us to submit it, if that's appropriate.
That'd be fine with me.
Okay.
We'll come up with a roster and then
I just have one last question. What are you anticipating as the effective date of this unit?
Let me respond if I may. Initially, when we had some discussions with the commission before the application was filed, I mean, the hope was that we could have something effective January 1. I think now we could probably push that off a little bit. Do you want to address that, Anna, as to could we go February 1 or are we still hoping for January 1?
I think February 1 would be all right. We've got wells that we have planned to drill, I believe, in April, the next 5 wells.
I was just trying to find our rig schedule real quick.
And we need to, have the location built on those, so we'd like to get permits on those sooner than later. So we would need either the DSU approved or the unit approved.
Yeah, I mean, obviously, January 1 would have been problematic with the commission meeting being December 17th, but February 1 should be doable.
Yeah, I think as Anna pointed out that, we had a very aggressive time frame initially, but some of those wells got pushed back a little bit, so we have a little bit more breathing room.
Yeah, and bear in mind, I guess I can look, the commission meeting in January is the 20th. So we would need, materials sooner rather than later to go through those and then get the order written so we can take it to the commission meeting on the 20th for an effective date of February 1st. And obviously, as Lawrence indicated, the commission has been willing in the past to delegate the authority to sign the ratification order. So that takes a little of that timing constraint away, but just to get the unit order itself to the commission on January 20th.
Well, we're really hopeful that if the director is given that authority to sign the ratification, that that will give us some time between now and prior to February 1 to have our meeting with the federal government and get them on board and initially submit their designation as a logical unit area and then to actually approve. So
Thank you.
You guys mentioned at least partially you don't have the 55% royalty interest, I believe it was. A couple of questions. When do you expect to, and kind of how far off are you?
maybe that'd be appropriate if we go to this exhibit and tell you what we have, and then we can, then Anna can offer some speculation as to when we'll be at 55%.
Attorney Bender, you can proceed with your
Okay.
witness.
Thank you, Mr. Examiner. Now I'd like to go for the pack of exhibits for case 32368. We'd like the entire 3-ring binder to be marked as Exhibit 1. And we'll have one witness. Witness has already been sworn, Anna Morgan.
Okay, you can proceed.
Anna, let's turn to Exhibit 1, which is the large 3-ring binder. And you don't have to go into a great amount of detail, but I do want you to identify the various matters that are contained in the tabs.
Binder.
Do you not have? The more of these I give up, so I have to haul one. Okay, so Anna, let's turn to what's been marked. Well, let's turn to Exhibit 1, and then let's turn to Tab 1 in Exhibit 1, and just very briefly identify what's contained in Tab 1.
Tab 1 is the unit agreement which details the procedures for the formation of the unit.
Okay, and this is the identical document that was addressed by you in case 32367. Is that correct?
Correct.
Only this exhibit is, or excuse me, this particular copy has a signature block completed by EOG. Is that correct?
Correct.
Okay, and then let's go to tab 2. What is tab 2?
Tab 2 is the unit operating agreement. Again, this is the same form that we discussed in the previous case.
And once again, this is executed by EOG. Is that correct?
Correct.
Okay, then let's go to tab 3, and I don't need you to go into a lot of detail, but perhaps explain the color scheme, explain what you're trying to accomplish with what's contained in tab 3, and then provide an answer to the question of where we are in terms of the ratifications for the royalty owners.
So tab 3 is a table showing the summary of the royalty interest owners in the unit. It details their interest and then whether or not we received their ratification and what interest was attributable to that. So the names or the rows that are highlighted in green are signed ratifications that we've received, and the peach color is indicated that we did not receive a signed ratification. On page 14 of 14 at the bottom, there is a summary showing that for phase 1 royalty interest, as of when this table was printed, we were at 52.20%. As of this morning, we had received an additional ratification, so we're currently at 53.37% for phase 1. For phase 2, we're currently at 57.72%, which is over the 55% threshold. So it's only phase 1 that we are lacking in that approval.
Now, Anna, you've been having communications with the various royalty owners who are part of this unit. Can you just briefly summarize what the attitude has been of those royalty owners? Are you getting telephone calls? And if you're getting telephone calls, are those telephone calls to express displeasure with the unit? Just tell us very, very generally what sort of reaction you're getting from royalty owners.
Yeah, I've talked to 100 people over the last several weeks. They're primarily calling just for an explanation. You know, I got this packet, what is it? I've explained to them what the process is for forming the unit and how it affects them. And the overwhelming sentiment is that they thought that their interest was so small it wouldn't make a difference. So that's kind of been the biggest issue. So trying to get people to actually return the ratifications has been the biggest issue, not necessarily that they're opposed to the unit. We did also, of note, receive 14 or 15 ratifications back in the mail that were unsigned. They took the time to fill in the date and put it in an envelope and return it to us, but there was a label print or that was stuck on there with their name and address, and apparently they didn't realize that they had to sign it as well. So we've been in touch with those folks. That would very easily put us over that 55%.
And you don't anticipate that Mr. Suggs is going to accept an unsigned ratification as approval?
No, those are not included in these calculations.
And Anna, there were some questions about state lands. The state of North Dakota has an interest in this unit. Is that correct?
They do, yes.
Can you identify on your document that's in tab 3 where the state of North Dakota's interest is designated?
Yes, on page 11. These are in alphabetical order. They're listed as North Dakota State Royalty Interest.
And can you indicate what the state of North Dakota's interest is in both phase 1 and phase 2?
8.612969% in phase 1, 6.693491% in phase 2.
And have you received any indication from the state of North Dakota that they will not support the unit?
No.
Okay, so you're anticipating that they may very well ratify, which would get you over 55% in both phase 1 and phase 2. Is that correct?
Yes, correct.
Okay. All right, let's go on then to tab 4. Can you just tell me what the documents are in tab 4?
These are the signed ratification and joinders to the unit agreement by the royalty interest owners.
Okay, and then tab 5. Can you tell me what tab 5 is?
Tab 5 is again a table of the working interest owners at this time, similar to the royalty owner list. And on page 3, you can see that we've received 83.69% approval from the working interest owners in phase 1 and 86.09% approval in phase 2.
And once again, a fair number of owners as working interest owners in this unit. Do you have the total of working interest owners?
How many?
Yes.
No.
Okay. But once again, as with royalty owners, any telephone calls, emails, letters from working interest owners saying, this is a really bad idea, or is it generally support or no comment at all?
Generally supportive. No one has opposed it. We've talked to multiple of these working interest owners.
And are you getting sort of the same reaction from working interest owners that you did from royalty owners? Is, hey, my interest is pretty small. I just don't want to spend any time on this.
Yes.
Okay. And then tab 6. Can you tell me what tab 6 is?
Yes, these are the signed ratifications that we've received from the working interest owners.
Okay. Mr. Examiner, no further questions. Offer Exhibit 1 in this case, which is case number 32368. And with respect to case 32368 and the previous case 32367, we'd respectfully request the record remain open. I think what we're going to request is that the record remain open indefinitely until we submit a letter, perhaps after communication between Mr. Suggs and I, that Mr. Suggs has all the information he desires, and then the record can remain. Then the record can be closed with respect to 32367, and then I think 32368 we'll want to leave open so that when we get the area of logical designation from the federal government, that can be submitted, as well as hopefully. I don't know if they call it a ratification, but their support of the unit. And as Ms. Morgan indicated, there's plans for a meeting with BLM later this month, and hopefully they will support.
Exhibit is admitted. Any questions, comments from the staff on leaving the records open indefinitely? Okay, so the records in both cases, 32367, 32368, will be left open indefinitely. Okay. Any questions? Okay. They'll be left open until they're closed by the commissioner.
Okay. And I guess one more thing. I know it was difficult to find a time for this hearing. I know the commissioner typically prefers to have these special hearings like the Friday after the regularly scheduled hearing. That would have been difficult for us to have it in November because we just weren't ready. December would have put it pretty late in the process in terms of trying to get an order relatively soon. So thank you very much for agreeing to the special hearing on this date.
Okay. Any questions from the staff?
Just a couple of quick ones, I think. The state lands ratification. Do you typically, I don't know, maybe this is a question Lars can answer. Do they typically ratify before or after a unit is approved?
I think it's been kind of an evolving process. There was a time when they would ratify early on, and then there was a period of time, given particular land commissioners' desire, is that they would not approve until they knew what the Industrial Commission was going to do. I had conversations with the Director of Minerals Management yesterday, and I'm not going to put words into his mouth, but the general impression that I got is that they would consider approving before the commission actually issued an order. So it has changed over the years, but I think where they're at right now is they would consider ratifying before ultimate order.
Okay, I was just wondering if that was going to be expected or potentially expected as part of your supplementals, or we'll need to see. Well, I mean, once we approve, provided we approve the unit, once we approve that, you'll have 6 months to get the ratifications in place, and so that'll need to come in that time frame.
We're going to have them to you a lot sooner than 6 months.
Okay. And then just one other question I was going to ask it about Exhibit B, but I can ask it here. On page 11 of your royalty interest list, right below the state of North Dakota royalty interest that you identified, there's well, 2 lines below, Office of Natural Resources. I was going to ask who or what that entity was.
That's the federal government.
That's the federal office? Okay.
And what's the acronym for that?
ONRR.
Okay. Oh, okay. And then when we have, excuse me, if I may, Mr. Examiner, and that's really the group we're going to be addressing our presentation to on the 16th.
Yes.
Yep.
Okay. I think that's all I got. Thank you.
Okay, that concludes our hearings for case numbers 32367 and 32368. That concludes our hearings for the day.
Thank you.
Thanks, guys.